afternoon and welcome to this lecture on public policy. My name is Robert Dijkgraaf. I'm Director and Leon Levy Professor here at the Institute for Advanced Study. And again, a warm welcome to this annual series of lectures that addresses issues of important and relevance to contemporary politics, social conditions, and scientific matters. We feel that we are extremely fortunate to have today a very distinguished speaker, Kenneth Roth, already for 20 years, Executive Director of Human Rights Watch. And he will be speaking on an issue that has been widely in the media and the public debate, actually for the last decade. His title is What Rules Should Govern Drones and the Broader War on Terrorism. Now, as you know, Human Rights Watch is one of the world's leading independent organizations dedicated to defending and protecting human rights with operations in more than 90 countries. And as a founding member of the international campaign to ban landmines, it actually shared the Nobel Peace Prize in 1997 for the banning and clearing of anti-personnel mines. And in 2008, it was a joint winner of the United Nations Prize for Human Rights. Mr. Roth is a graduate of the Yale Law School and Brown University, and he was drawn to human rights causes in part by his Jewish father's experience fleeing Nazi Germany in 1938. Prior to joining Human Rights Watch in 1987, Kenneth served as federal prosecutor in New York and for the Iran-Contra investigation in Washington, D.C. Since joining Human Rights Watch, he has conducted numerous human rights investigations and missions around the world, devoting special attention to issues of justice and accountability for gross abuses of human rights, standards governing military conduct in time of war, the human rights policies of the United States and the United Nations, and the human rights responsibilities of multinational businesses. Under his leadership, Human Rights Watch has documented war crimes in Bosnia, the Democratic Republic of Congo, Iraq, and Sierra Leone. Its researchers have testified at international tribunes, and the organization's work has helped to convict, among others, many for crimes against humanity. The latest case was perhaps Liberia's former president, Charles Taylor. In the past month alone, Human Rights Watch has issued reports on war crimes and crimes against humanity in Syria, land dispositions in the Ivory Coast of West Africa, policy violations against and seizure of goods from street vendors in Angola, government and private actor attacks on journalists in Yemen, and deliberate killing of unarmed civilians and wanton destruction of homes and villages by the Sekala rulers in Central African Republic. Well, many of you might also know Kenneth from his numerous articles and chapters, opinion pieces, on a range of human rights topics, with publications in the New York Times, the Washington Post, Foreign Affairs, the New York Review of Books. He also appears regularly in major media and speaks to audiences around the world. This past May, Kenneth testified before the United States Senate Armed Services Committee during its hearing on the law of armed conflict, the use of military force, and the 2001 authorization of use of military force. And in this testimony, he addressed three main issues. One, how the 2001 authorization for the use of military force should be understood today, whether it should be extended or modified. Two, what laws should govern drone attacks. And three, what should be done about Guantanamo and other long-term detention without trial. All topics, I think, which are very much in the public debate, and we, of course, look tremendously forward to hearing more of you from all of these policy issues. Now, Ken has said that he was quite willing to entertain questions, and so I think he will, this afternoon we'll both hear from him, but I also hope we hear from you and can have a wide-ranging debate. I don't think there's any lack of raw material for that discussion. Then actually after this, we will invite all of you to Fuld Hall for a reception, and there we can kind of continue the conversation in a more informal way. But now please join me in welcoming our speaker, Kenneth Roth, to the podium.
Well, thank you very much. It's a privilege to be here. I have to say that I'm used to writing articles on airplanes, And the idea of having an institute that gives you, the time and resources to actually, think and write and study without the day-to-day distractions that usually intrude on my life is something that makes me quite envious. So you all are rather privileged, not to mention the wonderful intellectual community that you have here. So thank you for inviting me and for letting me share in that community for an afternoon. I thought I would start with some of the canards that are often put out about drones, because drones are really these days the weapon that everybody loves to hate. And so let me begin with some of the things that are not wrong with drones before I get into what has been wrong with the way the drones are used. First of all, it's often claimed that targeted killings, the epitome of the use of drones these days, are inherently wrong. But if you think about it for a moment, that's just not the case. In war, you shoot the other side's combatants. Even the police officer on the street at times can legitimately use lethal force. So this absolutist view that targeted killing is always wrong actually doesn't correspond with the way the world works or the rules that govern institutions that we're quite used to. What about the ban on assassinations? Well, that ban is usually understood to apply to peacetime targeted killings, not war. I mean, obviously in war, you can again shoot at the other side's combatants, and the ban on assassinations has never been understood to prohibit that. Is it somehow unfair to be aiming at somebody, killing somebody, when you yourself are not at risk, when the drone operator is, sitting in Omaha or Kansas and going home for dinner with the kids? Well, there is something that is, morally disturbing about that, but it frankly isn't a whole lot different from the way, say, the fighter-bomber these days operates. Your typical American bomber is not in any meaningful sense in jeopardy as he flies over Afghanistan or historically flew over, Serbia or Libya. Most often, these fighters are operating in realms where there's not a lot of risk to them, and they are pretty much killing with impunity. Indeed, the same can be said of rocketing from afar, or even maybe the sniper who is firing and is not very much at risk himself. So, while there is something morally troubling about this idea of killing without yourself being at risk, drones are not that different from other kinds of warfare that we're used to. What about the argument that drones are indiscriminate? Well, it's true that there do seem to be a disturbing number of civilians who have been killed by drones, although that number is disputed. You sometimes get the Pentagon saying no civilians have been killed, which is much more a product of how they define civilians than a product of the reality. But if you think about drones, they actually in many respects are a human rights friendly weapon, in that they are first of all extraordinarily accurate. They hit what they're aimed at. And so while you can make a mistake in what you're targeting at, you can have bad intelligence aiming at the wrong thing, it's going to hit what you aim it at. And indeed, drones are able to linger and choose the most propitious moment to attack, one where there would not be civilians present. They can verify the target before firing in a way that a distant sniper or a speedy aircraft is unable to do. There have been problems about the training that drone operators receive. There's an interesting statistic, which is hard to verify, but that suggests that in Afghanistan, drones have actually killed more people than aircraft, despite the greater precision. And if that's true, and I'm not 100% sure it is, but if that's true, I think the reason for it is that the Pentagon does a better job of training its bombers to refrain from attacking in potentially troublesome situations for civilians than the CIA does for its drone operators. But if you look at the inherent capacity of the weapon itself, it is a very accurate weapon. So what's the problem with drones? Well, I think the main problem has been the way, the rules that have governed drone use. And here, for the purpose of the lecture today, I'd like to distinguish between two sets of rules: the rules governing war and the rules governing law enforcement or policing. And to grossly simplify, in war, it's legitimate for a combatant to shoot and try to kill a combatant on the other side. Indeed, any member of the opposing military is deemed to be a combatant and a legitimate military target. While a combatant can always surrender, and if you walk out with your hands up and your weapon down, you cannot be shot. But there is no requirement under the laws of war that somebody be given an opportunity to surrender. There's no requirement that the use of lethal force be the last resort. There's no requirement that the combatant whom you are targeting poses any kind of threat in the immediate sense, so long as they have the status of being a combatant. Now, that's all very different from the rules that govern policing or law enforcement, where lethal force can be used, but only as a last resort and only if necessary to meet an imminent lethal threat. Otherwise, the police officer on the beat has to try to arrest and prosecute the individual. He can't summarily kill him. Now, if you look around the world, there clearly today is a classic war, a classic armed conflict taking place in Afghanistan. So there's no question that the laws of war would apply to any drone use there. And I think you can argue that that war extends into the tribal areas of northwestern Pakistan, because the borders are fairly porous, and we know that the Taliban travel back and forth. So I don't quarrel with war rules governing drone use in Afghanistan, at least for the time being, at least through the end of 2014, when there's a significant US military presence there. But what should be the rules governing the use of drones elsewhere in the world? These days in Yemen and Somalia, the principal places where the US uses drones, but the US is setting up for the possibility of drone use in Mali. I think it's easy to envision the use of drones in northeastern Nigeria against Boko Haram. We're going to see, a greater and greater temptation to use this weapon, simply because it is a relatively risk-free weapon and very effective. So how do you justify the use of drones in these areas outside of a classic war zone? Now, the answer that the Obama administration would give you today is that there is a war going on there. It's the war against terrorism. Now, they eschew the Bush term, the Global War Against Terrorism, or GWAT as the acronym was in Washington. But they basically have the same theory, and that is that Al-Qaeda and its affiliates pose a continuing threat to the United States. Al-Qaeda is not limited to any territory. They may have started off in Afghanistan or Western Pakistan, but they have affiliates around the world. And given that this threat emanates globally, it should be met globally. If this was a war at its outset, it can be a war around the world. And therefore, combatants in that war on the other side can be shot. Now, there's a logic to that. It's internally coherent. But even Obama has begun questioning whether that war rationale should be applied globally. He gave a speech at the National Defense University this past May, where he warned about the dangers of perpetual war, as he put it. What does that do to a democracy? Jay Johnson, the man who has just been nominated to head Homeland Security, has also been quite eloquent about the need at some stage, he doesn't say when, to move beyond this war paradigm. Now, to understand why it is troublesome to use this war paradigm globally, let me just push the logic of it for a moment. Let's say that there is a terrorist, an Al-Qaeda member, walking down the streets of Paris or London. Could a US agent walk up and shoot him? Now, if this was really a war, the answer would be yes. He's a combatant. There's no need to offer him the right to surrender. A combatant can be shot whenever. I'm troubled with that. That doesn't seem like the right thing to do in a situation where capture and prosecution would be so feasible. Or to push a little further, we all know about the rhetorical war on drugs, but what if we treat this as a real war? Because, I mean, after all, if Al-Qaeda poses a threat to America justifying a war paradigm, why not drug traffickers? Why not the Mexican drug cartel, which surely is responsible for many, many more American deaths than Al-Qaeda has ever been responsible for? Why not shoot the drug dealer on the corner in downtown Princeton as the local representative, the local combatant of this drug trafficking cartel that we are at war with? Again, we would have qualms with this. If you allow this war paradigm to go that far, it creates enormous loopholes in the basic due process rights that we all take for granted. And if it seems far-fetched that the US would ever do this, just change the actors for a moment. Think about what would Russia do pursuing Chechen militants around the world? Would it think twice about executing them in London or Budapest or wherever they find it? Indeed, Russia's done some of that. What about China going after Uyghur militants around the world? Indeed, there was even a case recently where China was actively considering using a drone to summarily kill a drug trafficker on the Mekong River, someone who had killed some Chinese sailors. And rather than try to capture and prosecute him, they were going to use a war rationale and just shoot him with a drone. They didn't do that in the end. But it shows that we do have to worry about the precedents that are set. And the US isn't the only actor here. Indeed, China is now moving toward mass producing drones with stolen technology. But this relative monopoly that the United States and a few other countries now have on drone technology is short-lived. And soon, drones are going to be readily available every place. So the rules that America sets will be very important precedents for efforts to govern the use of drones by others as well. Now, these are all sort of logical or philosophic qualms that one might express about the use of drones. What does international law say about it? Now, international law does define what an armed conflict is. It does it in the Geneva Conventions. It does it through various international court judgments. It's not the part of the international laws of war or international humanitarian law that people usually talk about. They tend to focus much more on what are the rules governing the use of force in a particular situation. How do you make sure that you're not targeting civilians, that you're not firing indiscriminately, those sorts of things. But there actually are rules about whether war rules apply or not. And what those essentially require is a certain level of hostilities before the relative license of war rules apply. War rules are much more liberal about the use of lethal force than policing rules. And so you can't just pick your moment to choose to pursue war rules. You're constrained in that. And the time when war rules apply require a certain level of hostilities, which basically, it's not a clear-cut rule, but they look to certain factors. They look at the number, duration, and intensity of individual confrontations. Does this have the kind of regular battles of a war, or are the uses of lethal force by your opponent sporadic and isolated? They look at the kind of weaponry used. Are we using military weapons, or is it more policing-type weapons? They look at the number of participants in the fighting. Does this look something like an army, or are these just individual actors who look more like ordinary criminals? They look at the consequences of the violent exchanges. Do you see the kind of substantial casualties, the significant displacement that is associated with war, or do you see the disruptions of criminal activity? Now, when it comes to Al-Qaeda, there's no question that it still poses a threat to the United States. But I would submit that it no longer meets the standards associated with when you have an armed conflict. At most, what we have with Al-Qaeda is every once in a while an effort, fortunately usually unsuccessful, sometimes successful, but an effort to mount a terrorist attack. I don't want to minimize the significance of these terrorist attacks. We've seen most recently the Westgate shopping center in Nairobi, where you can have very significant loss of life. But these are quite isolated. They're dispersed. If they happen every several months, that's a lot. that is not the frequency, the regularity that one would associate with an armed conflict. That looks like serious, but nonetheless criminal activity. Indeed, Obama himself has referred to the core of al-Qaeda, the part that used to be around Osama bin Laden, as decimated. That's his term. The affiliates of al-Qaeda, the offshoots of al-Qaeda in the Arabian Peninsula or al-Qaeda in the Islamic Maghreb, are more robust these days. But they don't have much demonstrated capacity to project their criminal activity beyond their immediate regions. There have been occasional efforts by al-Qaeda in the Arabian Peninsula, the Yemeni-based one, to the underwear bomber, for example, to extend their terrorism to the United States. But that is extraordinarily rare and has fortunately been ineffective. So as you look around the world, I don't think the al-Qaeda affiliates look any more threatening than the Mexican drug cartels, which are a serious threat, but which most agree should be pursued under a criminal rather than a war paradigm. I should note that it's not enough that the United States uses military force in combating al-Qaeda to call it a war. That is one of the factors that I mentioned. But if it were sufficient to use military force, then the police could just roll a few tanks into downtown Princeton and use those to shoot the drug dealers and declare this a war, and therefore the summary use of lethal force would be authorized. That's obviously not the way it should be. Now, one argument that the United States could make but doesn't is that even if al-Qaeda doesn't pose any kind of sustainable, regular threat to the territory of the United States, that instead the U.S. is joining a local war. That there's a civil war in Yemen, and the U.S. is just joining into that war. Or there's a civil war in Mali, and the U.S. has become partners with the Malian government. It doesn't make this argument because the U.S. public wouldn't accept it. The U.S. public doesn't even accept we found going to war to stop mass slaughter in Syria. It's not about to accept the idea of going to war to join into a civil war, for the most part in countries they don't even know where it is, to stop something that doesn't pose any kind of sustained, meaningful threat to the United States. So in those circumstances, the U.S. doesn't argue that it's joining a local civil war. It argues that the U.S. is at war with al-Qaeda, a proposition that is increasingly difficult to sustain. Now, let me for a moment accept the administration's war rationale. Because even within a war paradigm, there are big problems with the way the drone war has been fought. For example, as I mentioned, war allows you to target a combatant. The so-called signature strikes that have been one of the more controversial aspects of Obama's drone policy seem to violate that requirement. What a signature strike is the idea of shooting at somebody when you don't know who they are, but they have certain attributes of being a combatant. Now, at a certain level, this is uncontroversial. If you're in a traditional war and there's soldiers shooting at you over there, you don't know their names, you just shoot back. But given the lack of firing back and forth, the lack of self-identification by these combatants, because there isn't a traditional armed conflict, a traditional battlefield, these signature strikes, these assumptions about who is or is not a combatant, matter a whole lot. And so, what you find the Obama administration implicitly doing, they never explicitly say this, they're quite secretive about it, but implicitly they seem to be saying that, if you're a young male, certain age, carrying a weapon, hanging out with the wrong people, you must be up to no good. That the local al-Qaeda affiliate wouldn't let you hang out with them if you weren't al-Qaeda yourself, and therefore we are justified in attacking you. That's basically the rationale behind the signature strikes. That begins to break down when you examine it more closely. For one thing, in a place like Yemen, every male of a certain age carries a weapon. So the fact that you're carrying a weapon does nothing to distinguish a potential combatant from an ordinary civilian. More to the point, while you could say al-Qaeda wouldn't let anybody hang out who isn't trusted, and that's probably fair enough, many people, even in a classic war, who are hanging out with the combatants are not themselves combatants. So under the laws of war, if you are a driver, if you're a cook, if you're a doctor, if you're even a financier, you get to hang out with the combatants, but you're not a combatant. You're not a legitimate military target. By treating all these people as effectively combatants under the signature strike rationale, the Obama administration is transcending even the relatively liberal, the relatively lax limits of the laws of war. And indeed, under the laws of war, if there's any doubt about whether somebody is a combatant or a non-combatant, the rules are you've got to treat them as a non-combatant, as protected. The Obama administration seems to be doing the opposite. Now, my argument that policing rules should apply rather than war rules do not mean that the United States is defenseless. And I think that's something that's very important to stress. Under policing standards, you still can use lethal force. Under policing standards, you could still use drones, but the rules are tighter. You can use lethal force of whatever sort only as a last resort. That means, only if you can't arrest the person. And even if arrest isn't possible, you can only use lethal force to meet an imminent lethal threat. Now, Obama these days and his colleagues are playing games with the term imminence. And they're able to do this because, just to confuse you, international law actually has two different meanings of imminence. There's one meaning that applies to the question as to when you can go to war, and there's another meaning that applies to the question of when you can use lethal force in a non-war situation. The question about when you can go to war comes up in the context of self-defense. It's understood that a nation can defend itself without waiting for its enemy to cross its territory. If the enemy is massing troops on the border and you face an imminent threat, you can preemptively fight back. That's legitimate under the concept of self-defense. But that's very different from the rules governing police officers' use of military force. There's good reason for treating the term imminent as really being imminent, because you can imagine what would happen if the police said, well, we don't want to wait till the last possible second. We want to nip the threat in the bud. So because we suspect that you're going to be committing a crime, we're going to shoot you as you leave your house. That in essence is the argument that the Obama administration is making, that they don't have to have a really imminent threat, that they can have sort of an anticipatory imminent threat, which doesn't make any sense, but that's in essence what they're doing. Yes, there are times when the police officer does have to use lethal force. If the gunman is holding a hostage, holding a gun to a hostage's head, there may be nothing you can do but to shoot. That is an imminent threat. But to get the gunman as he's leaving his house to, perhaps commit the crime, reminds me of the Spielberg Minority Report, where they were anticipating crimes, and punishing people before they would commit the crimes. On the question of last resort, one of the requirements of policing standards, what this is really about in the drone context is what kind of risks is the U.S. security forces, are they willing to assume? Because, in a sense, it's never a last resort in that you could always send in the Marines to try to capture the person. But that's dangerous. And so how dangerous is it? And what degree of danger, what degree of risk should U.S. troops be willing to accept before they say it's too dangerous, therefore that's not an option, therefore drones are the last resort? Now, Obama, again, doesn't talk about this. What Obama has been doing, beginning with the May speech, is inching toward the language of policing without going so far as to say that that's what he's doing. In his speech, he said that outside of the Afghan theater, outside the recognized battlefield, our preference, not our legal requirement, our preference, is always to detain, interrogate, and prosecute. So far so good. It'd be better if he said it was a legal requirement, but still. Um, he said, we act against terrorists who pose a continuing and imminent threat to the American people when there are no other governments capable of effectively addressing the threat. So there, it sounds like, imminence, last resort. Indeed, he went arguably even further than the laws of war require. He said, we won't act unless there's virtually no chance of civilian casualties, which even in a policing context isn't required, although that sounds more like policing. In war, you can, there's not a zero requirement of civilian casualties, it's a proportionality test. You can shoot at a military target knowing that civilians will be killed so long as the military target was worth it, so long as the effect on civilians was not disproportionate in relationship to the military benefit of hitting the military target. So basically, what Obama has done is articulate a series of policing standards that he now says are governing U.S. drone use outside of the traditional battlefield of Afghanistan. But he says this all as preferences, as options, as preferred policy, not yet saying this is what we are legally bound to do. Now, the good news, just a week ago, there were 2 Snatch operations, one successful, one not, in Somalia and Libya. I view this as a very positive step because in each of these cases, they could have just used a drone and killed the person, and they didn't. In each case, they took a risk. They sent in special forces and tried to arrest the person. In Somalia, they couldn't, and they had to back off. In Libya, they did. Now, they still are, paradigmatically confused because they took the guy captured in Libya, al-Libi is his name, and put him on a battleship in the Mediterranean and started holding him as if he was a combatant and interrogating him without his lawyer present. So they kind of fell back into the war paradigm, but then they went back to the criminal paradigm, and they sent him to the Southern District of New York to be prosecuted under an indictment in civil court. So, overall, I would say this is a positive step toward policing standards, but slightly schizophrenic, and of course still not done as a matter of legal obligation. It was done because they chose to do it. I guess the other good thing to note is that Obama has never sent anyone to Guantanamo. He hasn't succeeded in closing Guantanamo, but he has not added to Guantanamo. And the rationale for Guantanamo is a war rationale. These people are being detained for a decade, not as criminals. Most of them are not even charged, but rather as combatants. And if there is a war, you can hold the combatant, detain the combatant until the end of the conflict, when you have to release him or her and send him back home. Indeed, I think Guantanamo is very much lingering in the background of the drone debate, because one reason why Obama doesn't want to declare the war over is because of Guantanamo, because he's not sure that he wants to release everybody there. A good number, a majority, they have actually designated for release, and they're just trying to work out the parameters. But there's a core of about 40 people whom they don't have the evidence to prosecute, or they can't prosecute because of Bush's torture, but they're afraid are too dangerous to release. And they're trying to figure this out. And so if they can pretend it's still a war, they can say, well, we're just holding these people as combatants. We're perfectly lawful. It's also, but frankly, this war paradigm is leading to a number of bad policy decisions as well. I mean, one reason why the Obama administration is continuing to use these military commissions in Guantanamo rather than regular criminal trials in the United States is because if you're at war, you can prosecute the other side's combatants in a military commission. But these military commissions, unlike a classic court-martial where these are well-established institutions with established rules and a long history of fairness, these military commissions, they're making up as they go along. And so there have been big problems with them. These military commissions only prosecute war crimes, which is difficult because some of the crimes they want to charge people like Khalid Sheikh Mohammed with are not war crimes. They're things like material support for terrorism, which is a civil crime, not a war crime, and therefore the courts are ruling that this crime is ineligible for the military commissions. Even the crime of conspiracy is not a classic war crime. It's a federal crime, civil crime. And this, too, they're having a hard time prosecuting. They are making up evidentiary rules as they go along. They actually have a rule that while you cannot introduce the coerced statement of a defendant, you can introduce the coerced statement of a witness. I mean, this would never pass muster in the regular courts. It wouldn't even pass muster in a court-martial. But there it is, written into the military commission rules. And these are just, this is what happens when you build a system from scratch for largely ideological reasons rather than, kind of looking at more with wider eyes, clearer eyes, and using the court system that would have been most effective. And I say most effective because Guantanamo military commissions have not convicted anybody in the last decade in a contested trial. There have been a handful of guilty pleas. No one has been convicted after a trial, during a period where hundreds of terrorism suspects have been convicted by the regular federal courts. So this is not a matter of, what's the best way to get these people. This is a matter of ideology, of saying, this is a war, and so, okay, we'll treat some of these people as if they're warriors, as if they're combatants, and use these military commissions. I think the war paradigm, frankly, has contributed to the use of torture as well, which Obama has stopped, but obviously plagued the Bush approach. Now, torture is prohibited in war, too, but if you say you're at war, it's easier to move on to these kinds of excesses of the Bush coercive interrogation. And I just think that the ambience, the environment of war, has not been helpful in terms of setting good policy approaches. You see the same thing, frankly, with electronic surveillance, where if we had been operating under a criminal paradigm, the Bush and now the Obama administration would have been much more careful about abiding by the laws when they wiretap. Because if the aim was to introduce, ultimately, evidence at a criminal trial, you know that the way you procured that evidence is going to be tested by an independent judge. But if you're at war, you don't worry about those niceties. And so, we've seen, extraordinary overreach in the NSA's electronic surveillance without much thought about judicial oversight, indeed doing everything they can to avoid judicial oversight other than the FISA Court. And the FISA Court has been completely abused itself. I mean, it's one thing to have a secret court if the issue is simply, getting a wiretap, a focused wiretap, because obviously you can't inform the target of a wiretap that you're about to put it on them. That would defeat the purpose. So you do need something that is secret and ex parte. But why is this FISA Court moving beyond decisions on particular wiretaps to making decisions of broad policy? That none of us have a privacy interest in our metadata, or that no foreigner outside the United States has any recognized privacy interests at all. I mean, these are incredibly controversial positions that have been guarded from any public scrutiny by having a secret court decide these without even hearing the other side, just talking to government lawyers. So you can see how this war paradigm lends itself to this kind of overreaching. Now, to return to drones, and let me just take a moment on the idea that has been kicked around a bit. Should there be a FISA court for drones? There is something problematic about the executive on its own choosing who to target, regardless of what the rules are. And some have suggested, well, let's extend the FISA court to that. I don't think that that's feasible, in that the most a FISA court could do would be to decide who is an appropriate target. But even then, it would be incapable of deciding whether a particular drone attack was legitimate or not, because these kinds of attacks are so situational. Are there civilians around? Is this the moment at which there are the fewest potential civilian casualties? Are these signature strike people appropriately viewed as combatants or not? I mean, these are the kinds of day-to-day decisions that a targeteer must make. They don't lend themselves to prospective judicial judgment. They do, I think, though, lend themselves to retrospective judgment. And while you would say, well, what good? The person's dead. What good does it do to be able to challenge in court? I do think there's something to be said for the survivors of a drone attack to be able to challenge the attack in court, because it does start to draw up rules. And I think one of the big problems has been the lack of recognition of any binding rules on the part of the U.S. government. So why is the Obama administration not sort of living up to the logic of what even it is saying? Why doesn't it formally adopt policing rather than war rules? Well, I think the dominant factor, to be honest, and it's not a pretty factor, is politics. I think the Obama administration is afraid that they would be creamed if they declared the war over with. They're terrified that the next day there would be a terrorist attack and the right wing would say, aha, this is what happens when you let up on the war, and it would be politically devastating. What was the guy's name? Under Michael Dukakis, Willie Horton. Yes, they're all kind of worried about the presidential Willie Horton effect, that you do something and it'll come back to haunt you, and that's widely seen as having destroyed Dukakis' candidacy, and what would this do to the Democratic Party? So there would be a political risk in declaring the war over with, and I think we have to recognize that. But there's a risk with the status quo as well. It tremendously diminishes the status of the United States around the world. This excessive use of drones is extraordinarily controversial when you go around the world. It is generating animosity, particularly among the exact group who you might say are the swing voters of terrorism. The angry young men who might or might not join the terrorists. And it's not enough to sort of stop today's terrorists. You've also got to make sure that you're not creating tomorrow's terrorists. In the past, Guantanamo was the big recruiting tool. Today, it's drones. And so if the US wants to worry about preventing the next generation of terrorists, it should look very closely at the way it is deploying drones. And then obviously, as I mentioned, we are in a period of relative US monopoly over this technology that is not going to last. And so this is the easiest moment to set the rules, and we're doing a poor job of it. We're setting lax rules that I'm afraid will come back to haunt us. So for reasons really of principle and pragmatism, I submit that it's time to leave the war footing outside of the recognizable battlefield of Afghanistan. We still face a serious threat from Al-Qaeda, but we're way past the point where the law can justify treating this as a war, and the consequences now of continuing to be at war are greatly outweighing the advantages of doing so. So let me stop there, and I'd welcome your thoughts or questions.
Thank you very much for a quite insightful lecture, with also, I think, many opportunities to ask questions, and really would like to invite the audience to comment, and there are microphones for your question. Can you take the question?
Of course, yes, please. Yes.
Hi, thank you for navigating a very complex path for us. I'm curious what you think about the international community aiding this debate, and what kind of efforts you've had with the international community to take a leadership role in solving and helping create some better guidelines.
Well, first of all, I should say the U.S. is almost allergic to the idea of submitting these kinds of issues to international debate. There is a lot of concern, but because the U.S. is by far and away the most dominant protector of the West, the governments that are most likely to express disquiet with this approach, the NATO partners, for example, don't very much. There's very little, if any, public challenging of what's going on the part of the major Western partners to whom the Obama administration would be most likely to listen to. So you occasionally get a UN special rapporteur or a UN committee addressing these issues, but those are much less persuasive in Washington than London or Paris or Brussels would be, and you don't hear much from them.
Is that part of your mission, if I may ask a follow-up? Is your organization trying to spearhead some of that dynamic, in the sense of if terrorism occurred more readily throughout the partnerships of the West or more neutral countries, then there would be a real driver, of course, for this debate to spark up. If bombs went off in Amsterdam and Berlin and that down the line, is that part of your mission to stimulate that discussion, or are you focused mainly on the U.S. specifically because it's such the epicenter of the issue.
Yeah, I mean, ordinarily we are very concerned with the debate, elsewhere. Right? And one way we get things done, we have researchers or investigators based around the world collecting information in countries with serious abuse, and we then appeal to influential governments wherever they are to try to put pressure on the target government. And so, in addition to our research capacity, we have advocacy and press capacity, and in Europe we have major offices in London, Paris, Brussels, Berlin, Geneva, and then elsewhere around the world. And so we're quite used to engaging those countries in this debate. We find that they're not interested in engaging in this debate. I mean, and frankly, Europe has done a better job when it has faced terrorist threats, whether it's the bus bombings in London or the train bombing in Madrid. Europe is not immune to this, but they have responded through a criminal paradigm, not through a war paradigm. They have not been outspoken, to the least, in criticizing the U.S. war approach. And it's been a disappointment. But as a result, our focus is much more on the U.S. debate, because that's what's going to make the difference. I'll leave it to you guys to choose.
So when we talk about drones, we're talking about violence that fits our normal definition or understanding of it, but an idea that's increasingly common within critiques of violence in the global order is slow violence. Things like deforestation, pollution, the release of chemicals and toxins into the environment. And so my question is, to what extent does Human Rights Watch see that as part of the paradigm that you are fighting or engaged in? Because clearly, when we're talking about drones, ultimately, if we step back far enough and look at the picture from a very broad perspective, we're talking about U.S. actions undertaken because of a corrupted and completely misguided energy policy, right? Arguably, the money that we spent on the two wars, we could have used to convert to a completely sustainable energy economy. At least there are sustainability scientists who would argue that. So to what extent does Human Rights Watch engage in these larger issues about the role of corporations in these discussions and the place of indigenous peoples and their rights to their land, to their own integrity?
Right. Well, okay. I don't subscribe to this expansive concept of violence. I mean, violence is when you're hitting somebody or shooting somebody. The other things are bad. You can just call them what they are. You can call it pollution, environmental damage, threats to health, what have you. I don't feel like you need to elevate the harm by using the term violence, so I don't. But with respect to does Human Rights Watch look at these broader issues, many of them, yes. I mean, just to give one example, we're used to thinking of human rights as the right not to be tortured, the right not to be killed, the right not to be unjustly imprisoned, but there are also so-called social and economic rights, for example, the right to health. And so we have a program that looks at ways in which governments do not conscientiously promote the right to health. To give an example, we did a project just recently in Bangladesh where the government allowed tanneries to exist in the middle of urban areas, spewing out toxins. And there was no reason why they should be based there. They were killing people needlessly. And we did a report, and the government has now agreed to kind of move the tanneries to less populated areas. We just did something looking at the use of mercury in artisanal gold mining, where children were really being poisoned and their brain capacity harmed because, not that the government was doing this to them, but the government was not educating people about how toxic mercury was. And so we actually just got a treaty adopted imposing on governments the obligation to try to prevent this kind of mercury poisoning. So we do get into these issues, but we do it sort of, not under the rubric of violence, but the kind of the more classic rubrics of right to health or the like.
Thank you very much for a very, very stimulating talk. I have a couple of questions that I wondered if you could say a little bit more about. One is this apparent contradiction in the administration's position between considering this a war or not, and in that respect, applying the laws of war or not applying the laws of war. And to the extent that it is considered a war, then the question is, well, for example, why are there not then prisoners of war camps that apply the actual law of war on prisoners of war, which I don't think is being applied, at least not consistently. That's one aspect, and there has been a kind of denial that these are, in the beginning at any rate, prisoners of war and legal combatants. They have been described as being illegal combatants, which is a category that is not very easily, you can't find it in international law very easily. The other question is, and I wondered if you can say a little bit more about it. The other question is your approach in relation to promoting the policing side as opposed to the war logic, the policing logic. And there you haven't said anything about the issue of sovereignty of the states in which such policing is taking place by the United States, and what rules should apply in that case. You've implied that most of this happens, or that this happens in places where there is not a, or at least that the administration argues that this happens in places where there is not an effective government, and yet some of the attacks or snatches have taken place in areas where there is arguably a functioning government. And then in this relation also, how would, using your earlier example of looking at how we would view it if other countries were to apply a policing logic to intervene in X number of countries to snatch or prosecute or kill others under the definition of terrorism, like the Chechens or the Uyghurs, according to those countries' definitions, what would then be the logic as applied by the United States?
Okay, good questions. In terms of the prisoner of war question, the relevant law here is the so-called Third Geneva Convention of 1949. And for our purposes, let's focus on two attributes of a formal prisoner of war under Third Geneva. One is that Third Geneva only applies to intergovernmental conflicts. So if the United States is fighting Canada, soldiers captured on both sides get full Geneva Convention rights, and there's a very detailed protocol about how they have to be treated. The Third Geneva Convention does not apply to a conflict between a government and a non-governmental entity like Al-Qaeda. So no one really claims that the Guantanamo detainees should be treated as Third Geneva prisoners of war. The other essential factor of being a prisoner, a Third Geneva prisoner of war, is that you get the so-called combatant's privilege, which means that you cannot be prosecuted simply for shooting at my side's combatants, that the mere taking up of arms is protected, because that's what soldiers do, as opposed to war crimes. If you shoot at civilians, if you torture, if you fire indiscriminately, then you can be prosecuted. The combatant's privilege doesn't extend to war crimes, but it does extend to the mere taking up of arms. That's under Third Geneva. If you are an unlawful combatant, i.e. you're not entitled to Third Geneva protections, then you can actually be prosecuted for the mere taking up of arms. So even an Al-Qaeda operative shooting at a US soldier, which under a Third Geneva paradigm would be protected, as an unlawful combatant, it's not protected. So those are the consequences. I mean, that's why there is no prisoner of war protocol for Guantanamo. On the sovereignty question, I mean, first, as a factual matter, the US claims that it's operating with consent in most of these places, and therefore there is no sovereignty violation. And that certainly is true in Pakistan, even though the Pakistanis hate it, but they have an odd form of consent where it's understood that this is allowed, but the Pakistani government will protest anyhow to placate its public. It's certainly true in Yemen, where they very much are operating with governmental consent. Somalia, there's been no effective government, but these days, where there is a kind of a new government, they're all for US attacking al-Shabaab. So again, there's no real problem there. This recent snatch in Libya, there was some controversy as to whether the government knew or not. You have the difficulty in Libya that the government isn't really in charge. Libya these days is governed by a series of local militia. But to take it away from the facts for a moment, to look at just the theoretical question, sovereignty is not an absolute value, and I think that if you were to go to the right of self-defense, that would justify violating sovereignty if there were an imminent threat to your country, your territory. And so, even in a policing context, I think you would look to the rules on self-defense to decide whether sovereignty could be violated in order to go after a threat. But if that threat was a non-warlike threat, you would still want to follow policing rules in terms of the lethal force that may or may not be used. So that's conceptually how I would analyze it.
And Immanuel Kant, in his earlier writings, he actually praised war. So this is good for the warrior because it make them feel sublime. In the later writings, he changed, at least in the way he wrote about the subject. He said the war is nothing but to make the warrior feel they are so great, they are so invincible. Their whole aim is destruction. And I think one can think about the example of that related to what when President Bush had the mission accomplished sign in the aircraft carrier. I think it's very clearly description of that. So the question is that Kant did not say what is the criteria. How do we know that a warrior go to war? He's engaged in self-aggrandizement. I'm so great. Now, here I want to ask you, with this weapon, the drone, like you said, it's effective, it's perfect, it's accurate, and on top of it, it's one-sided. Namely, I can do you, and you cannot do to me. And at least, like you said, in the present period. So, to me, this is a good criteria. In such a case, I can use it, and I can use it anonymously. It seems that it satisfies the criteria, or the thing which Kant did not provide. Such a weapon, by its very nature, that is a proof that he who uses it is engaging in a self-aggrandizement. Namely, I am so great, you're not so good.
I mean, you're right that, anybody who has a gun, obviously there's this power that goes with that. And that lends itself to abuse, almost inherently, that kind of power discrepancy between those who are armed and those who are not. And so, I do think that it was very much, kind of a Kantian perspective that helped to develop limitations on when force can be used. And there essentially are two broad areas of restraint. The Latin terms are jus in bello and jus ad bellum. Jus ad bellum is, when is it appropriate to go to war? When are you allowed to initiate armed conflict? And jus in bello is, what are the rules within that war? The jus in bello are basically the Geneva Conventions, what's known as international humanitarian law. Jus ad bellum is where the law of self-defense comes in. It's where the law of humanitarian intervention comes in. The international law is not pacifist. It doesn't say war can never be used, but it tries to impose restrictions on that warrior's self-aggrandizement by saying that there are only certain moments where war is legitimately used. And this is still very much in debate. Self-defense is the relatively easy concept. But the idea of humanitarian intervention, the idea of using military force to stop genocide or to stop mass slaughter, remains a very controversial issue. And in fact, the UN 5-6 years ago adopted a concept known as the responsibility to protect. But even that was very qualified and essentially requires Security Council checkoff before a government can use lethal force to stop mass slaughter. My organization, Human Rights Watch, actually doesn't even subscribe to that requirement because what it basically means is that if you're a friend of one of the permanent 5 members of the Security Council, you will never face humanitarian intervention and you're free to commit mass slaughter. That's the problem in Syria today. Russia's protecting Syria from the prospect of international intervention to stop the killing. And so given the unfairness of the Security Council, we as an organization don't require that Security Council sign off. But under the responsibility to protect, that's a requirement. And so we're in a very kind of imperfect state of international law in terms of trying to restrain that warrior's ethos in the jus ad bellum area. In an area where many people feel there is a role for military force, but they're unsure how to properly constrain it. Yes. Precisely. I mean, that's the Kantian perspective. Absolutely. And that's what the...
That is clear to us.
Yes.
Then we always moral. We were so muddled.
Yeah. I mean, I think that is the perspective behind the laws of war. And I quarrel really less with the laws themselves than with, we focus more on compliance. We largely accept those laws, and they do adopt that Kantian perspective. Yes.
Sorry, perhaps the last question. Okay. Just wait for the microphone.
Just to follow up on the morality issue, I guess when you're describing these signature strikes, from the investigations that your organization has completed, is there, when the U.S. government gives authorization for those strikes, is there any sort of method by which there's advocacy for the human rights of that victim or that target, such that on the basis of a legal decision to move forward with that mission, there's some sort of at least paper justification for moving forward with it?
Well, I mean, yes and no. Some had proposed, having a kind of a devil's advocate within the executive branch who would argue the would-be victim's point of view. And that institution does not now exist. For named targets, there is a fairly elaborate internal review process where a significant number of officials do look through the paperwork and sign off on it. I'm not sure to what extent that still is in place. It's hard to do that for signature strikes. But certainly for when the system started, that was there.
Well, because I'm thinking of a particular signature strike that was, I think, a few years ago, where I think it was a 15-year-old teenager was taken out by a drone strike because they thought this young man was a relative, or was a relative, but was actually engaged in planning terrorist attacks. And in turn, it turns out that he was not, and that he was just visiting a relative in the area. This was in Yemen, I believe. I was just, in reading that account, it just struck me that, who was really thinking about how that particular individual qualified as a target, and how the logic process to assume that, they had to take that person out now, as opposed to waiting to see if he actually committed any acts that were suggestive of a terrorist intent.
Yeah. Well, I mean, this is precisely these are the issues that we ask about. We know very little about the mechanics of this review process because it's all super secret. But if you look at the results, one, there are clearly intelligence failures, and it's worth asking why did things break down so much. But second, this elastic concept of imminence is part of the problem, because it's hard to make the case that this person is imminent. And at that stage, which was I think a couple years ago, they still were probably much more in the war paradigm where they don't really ask about imminence. They just say, is this a combatant? We're at war, we can shoot him. These days they are asking more about imminence, and I think it would be harder to make that case. We're trying to get them to consider imminence a legal requirement rather than a policy preference. But we do seem to be moving in a better direction in that sense.
Well, only want to thank you again for giving this very thoughtful, balanced, and nuanced presentation, which I think only underlined the strength of your arguments. And so I feel we were very fortunate to have this conversation. And I think just on behalf of everyone, I want to thank you and also encourage the work that you are personally doing in your organization. So thank you very much for coming here. And please join us for a drink at Volt Hall.